Now let's have a look at section 155. It talks about impeaching the credit of the witness. Now there are only three ways to impeach the credit of the witness. First is by evidence of the person who testify from their knowledge that the witness is unworthy of credit. Secondly, that the witness has, by proving that the witness has accepted bribe or accepted the offer of a bribe or any corrupt inducement. Thirdly, by proof of former statement inconsistent with any part of his evidence by which he is liable to be contradicted. Now have a look at the explanation. It simply says, a witness declaring another witness to be unworthy of credit may not upon his examination in chief give reasons for his belief, but he may be asked his reasons in cross examinations, and the answers which he gives cannot be contradicted, though if they are false he may afterwards be charged with giving false evidence. Why can't he be contradicted? Under the explanation, see, this section is a re-echo of section 153. It is speaking in context of section 153. The explanation is speaking in context of section 153. That is why it is saying that he cannot be contradicted. But if his answers are false, he may be afterwards charged with giving false evidence. So understand that the explanation is a re-echo of section 153. Now look at the illustration. Illustration says A sues B for price of goods sold and delivered to B. C says that A delivered goods to B. Evidence is offered to show that on previous occasion he said that he had not delivered goods to B. The evidence is admissible. Why? Because his previous statement and the current statement is being contradicted by one another. Okay? At least one of them has to be false. Then we look at illustration B. A is indicted for murder of B. C says that B, when dying, declared that A had given B the wound of which he died. Evidence is offered to show that on previous occasion C said that the wound was not given by A in his presence. The evidence is admissible. Why? Because statements are being contradicted. His former statement is inconsistent with his latter statement. That is why, by way of contradiction, it is being admitted. Now you must also know one thing, that under certain circumstances material omissions can also amount to contradictions. Alright, material omission can also amount to contradiction. That is, omitting to say something that is material under certain circumstances can also amount to contradiction. So just keep that in mind. Now I have a situation for you. Let us suppose there is a witness named A who says B is unworthy of credit. Alright. In accordance with section 155 subsection 1, he testifies in court that from his knowledge B is unworthy of credit. Then comes another witness C who says A is unworthy of credit. Then comes another witness D who says C is unworthy of credit. So the question crops up that how far this chain of recrimination can be allowed. कितनी दूर तक ये अलाउ किया जाएगा. तो इस पे एक मैक्सिम बता देता हूँ. मैक्सिम है in testum test et in hos sed non datur ultra. It means discrediting witness may himself be discredited by other witness, but no witness can be called to attack the characters of these last. ठीक है, फिर से बता देता हूं. इन टेस्टम TESTEM टेस्ट्स TESTS टेस्टम के बाद टेस्ट्स, फिर एट इन हॉस ETINHOS, फिर सेड नॉन डेटोर अल्ट्रा SEDNON DATUR ultra ULTRA. It means discrediting witness may himself be discredited by other witnesses, but no further witnesses can be called to attack the character of these last. So, let me just explain it by an illustration. Let us suppose A says that B is unworthy of credit. Then you can call C to say and depose before court that A is unworthy of credit. But no further witness can be called to attack the character of C now. Alright. So this is the limit. Because court doesn't want to go into an unlimited inquiry or there would be a never ending chain. Okay? So in this section there is no complexity. We move on to section 156. It says, when a witness whom it is intended to corroborate gives evidence of any relevant fact, he may be questioned as to any other circumstance which he observed at or near the time or place at which such relevant fact occurred. If the court is of the opinion that such circumstances, if proved, would corroborate the testimony of the witness as to relevant fact which he testifies. Illustration. A, an accomplice, gives an account of robbery in which he took part. He describes various incidences unconnected with robbery which occurred on his way to and from place it was committed. Independent evidence of these facts may be given in order to corroborate the evidence as to the robbery itself. So basically, so far we saw that the legislature indicated to you that how a witness may be contradicted under section 145, 153, 158, etc. Now you need to see that under what circumstances the witness may be corroborated. First is under section 156. Second is former statements made by him may be proved to corroborate later testimony to the same fact under section 157. These two are the most popular form of corroboration. The third is when any statement is relevant under section 32 or 33 and is proved, all the matters may be proved either to contradict or corroborated in accordance with section 158. So understand, corroboration is meant to test the truthfulness of the victim. Contradiction is also there to test the veracity of a witness, but corroboration is also meant to test the truthfulness or veracity of a witness. So one of the best way to test the veracity of the witness is to ask him question as to any other circumstances which he observed at or near the time and place as to the relevant fact. Now let us suppose A, while committing robbery, is actually seen by B. Alright. A was committing robbery and B actually sees him. He is an eyewitness. Now B deposes before court that he saw A committing robbery. Now in order to corroborate it, the question may be asked about him that, okay, what were the circumstances at or near that time? What happened? So he may depose that, okay, during that time, at or about the hour when A was committing robbery, there was a power cut in the area and there was a political party rally going on. And he mentions the name of the political party. Now, independent proof is given about these circumstances that yes, there was a power cut in that area at and about that particular time when A is believed to have been robbing. Secondly, there was a rally going on by a political party, and name any political party in your mind, and it is proved that actually a political rally was going on. So in that situation, B is corroborated by the circumstances which took place at that relevant time. So since he is narrating those things, it means presence of B at that particular spot cannot be doubted. Okay, at least for now. So his evidence about these circumstances actually corroborates his testimony. So the court believes that yes, he might be telling the truth because he was at that particular spot. And since he was at that particular spot, he is also corroborated by relevant facts which happened on that particular spot. For the sake of our illustration, it was a power cut and a political rally which was organized by a political party. He deposed as to both of the facts. So if it is proved that the power cut actually happened at or about time the B is saying the power cut happened and there was a political rally going on and the independent evidence is given of these circumstances, then these things will corroborate the testimony of B. So this is just one of the illustrations on which section 156 applies. The ambit and scope of section 156 is very vast. It is not confined to just the illustration that I gave, but the illustration is just there to give you a working idea that how this section will operate. Then we can move on to section 157. It says, in order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate that fact may be proved. Now, there are only two things which are essential for this section to apply. The first is that the witness should have given testimony with respect to some fact. Second is that he should have made a statement earlier with respect to the same fact at or about the time when that fact took place or before any authority legally competent to investigate that fact. Generally, the statements made immediately on occurrence of an event contain truth, for no time has elapsed for concoctions to creep in. Similarly, statements solemnly made in presence of a legally competent authority also bear an impress of truth. Hence, statements like these are legitimate modes of corroboration. Now, one thing that I have to clarify. FIR that is recorded under section 154 of the CRPC can be used for corroboration and contradiction both, but it is not a substantive evidence. You should be very clear about that. Secondly, statements under section 161 cannot be used for corroboration. Be very clear about that thing. Statements under section 161 of the CRPC, statements which are recorded under section 161 of the CRPC cannot use for corroboration. Why? Because 162 explains that they can only be used for contradiction, otherwise it generally has no legal use unless it comes within one of the exceptions of dying declaration or disclosure statement. Otherwise, generally you cannot use a statement made before a police officer once the investigation has begun. So, 161 statements cannot be used for corroboration under this section. You should be very particular about that. FIR can be used. FIR can be used for corroboration and contradiction both, because the bar of section 162 does not apply on an FIR. The bar of section 162 of the CRPC only applies when the investigation has begun. So I just want to tell you a point in CRPC that section 161 is outside the scope of section 157. It cannot be used for corroboration. It can only be used for contradiction. Generally, general rule. However, statements under section 164, statement recorded under section 164 of the CRPC can be used both for corroboration and contradiction. Alright. Under section 164 of the CRPC, statements can be used both for corroboration and contradiction. So, on that section 157 will apply. There, the former statement made before a legally competent authority can be proved. Okay? 164 statement are also formal statement and can be used for corroboration. Likewise, FIR can be used for corroboration and contradiction. Section 164 statement can be used for corroboration and contradiction, but section 161 statement can only be used for contradiction as a general rule and can only be used in accordance with section 162. 161 के जितने भी 161 में जितने भी स्टेटमेंट रिकॉर्ड होते हैं उन स्टेटमेंट का क्या करना है वो सेक्शन 162 CRPC बताता है. उसका स्कोप बहुत ज़्यादा नहीं है, क्या कहते हैं उन स्टेटमेंट्स का, बिकॉज सेक्शन 162 इज अ restrictive clause. It mandates that ordinarily no statement given to a police officer once the investigation has begun can be used at any inquiry or trial. And if such statements are duly proved, मतलब विटनेस आ जाता है कटघरे में और वैसा ही स्टेटमेंट दे देता है, तो उसके फिर फॉर्मल स्टेटमेंट कैन बी यूज फॉर कॉन्ट्रडिक्शन. उससे ज़्यादा उसका कोई यूज़ नहीं है अनलेस इट कम्स विद इन डाइंग डिक्लेरेशन और डिस्क्लोजर स्टेटमेंट. उनका पर्पस सिर्फ कॉन्ट्रडिक्शन के लिए ही हो सकता है जनरली एज अ जनरल रूल. अब सवाल उठता है कि एनी फॉर्मल स्टेटमेंट का क्या मतलब है. सी सच फॉर्मल स्टेटमेंट मे बी रिटन, वर्बल, इट कैन बी ऑन ओथ, इट कैन बी ऑर्डिनरी कन्वर्सेशन. A witness account book duly kept in ordinary course of business may also be used under this section for corroboration. Likewise, statement of a victim of sexual offense who makes the statement immediately after the occurrence is admissible as a previous statement in terms of section 157 or according to section 8 of the act for the purpose of corroboration only. सेक्शन 8 के हिसाब से वो कंडक्ट दिखाएगा सब्सिक्वेंट, और सेक्शन 157 के स्कोप से जब आप रीड करेंगे सो दो स्टेटमेंट्स कैन बी यूज्ड फॉर corroboration. Now comes the situation, what do you understand by these words at or about the time when the fact took place? Now these words indicate that the statement must be made at once or at least shortly after when a reasonable opportunity for making the statement present itself. But obviously our time limit has not been established. Then where do we get a standard for applicability of section 157? In the case of state of Tamil Nadu versus Suresh, AIR 1998, Supreme Court page number 1044, the Supreme Court said that we think that the expression at or about time when the fact took place in section 157 must be understood in context according to the fact and circumstances of each case. So there lies your answer. It will be construed in accordance with fact and circumstances of each case. And the test is to be adopted is this: did the witness have the opportunity to concord or to have been tutored? ठीक है, ये सवाल कोर्ट खुद से पूछेगा. Did the witness have the opportunity to concord or have been tutored? अब कुछ circumstances में delay of a few days wouldn't matter, but under other circumstances and under certain fact of the case, delay of a few days might not be used for the purpose of corroboration. अगर कुछ दिन का delay हो गया, then the statements cannot be used for corroboration, while in fact and circumstances of other case, those statements can be used for the purpose of corroboration. Let me give you an example. मान लीजिए डिस्ट्रिक्ट मैजिस्ट्रेट को नक्सल उठा के ले गए जंगल में. अब डिस्ट्रिक्ट मैजिस्ट्रेट किसी तरीके से अपने रस्सियाँ छुड़ा के भागता है, ठीक है. अब जंगल में उसे रास्ता पता नहीं है, सो ही कीप्स ऑन रोमिंग, एंड आफ्टर अ स्पैन ऑफ 5 to 6 days he actually reaches a city, and after getting himself healed by a further 3 to 4 days, by a further 3 and 4 days, he lodges an FIR under section 154 of the CRPC and narrates the entire incident. An FIR is lodged accordingly. The district magistrate, while he was recovering, also gives his statement to the doctor. Now when this fact will go before the court, can the defense use the delay of 6 days while the DM was inside of a jungle finding his way en route towards the city? Can a delay of 5 or 6 days be held to be so fatal for corroboration that the statements cannot be corroborated at all? Or when he was recovering in the hospital, can it be said that those statements cannot be used for corroboration because by that time 8th day has expired? The answer would be no, because in fact and circumstances of this case, there was no opportunity to concoct or to have the witness tutored. In those situations, it would be entirely permissible to corroborate the former statements made before the doctor, the FIR and the other witnesses to corroborate the testimony that is actually deposed before the court. Okay? But in certain circumstances, let us suppose two neighbors fight with each other, and one of the neighbor tries to commit murder. Okay? Tries to commit murder, doesn't succeed. So the other neighbor on which attack happened, let us call him B. उसका नाम B है, ठीक है, जिस पे अटैक किया गया. He just wards off the attack and stays at home for, let's suppose, a week. 1 वीक के लिए रहता है। उनके घर से, नेबर्स के घर से पुलिस स्टेशन कितनी दूर है? लेट अस सपोज 50 मीटर्स, 50 मीटर दूर है। अब जो बी है वो चाहता है, कुछ लोगों से कंसल्ट करने के बाद वो कहता है कि इन पे हम एक FIR लॉन्च करवा देते हैं। ठीक है, ध्यान रखिएगा, यहाँ पे एलिगेशन है अटेम्प्ट टू मर्डर, यहाँ पे अटेम्प्ट टू मर्डर हुआ नहीं है क्योंकि कोई इंजरी उस पर नहीं है, ना सिचुएशन कोई ऐसी है जो दिखा पाए कि उसके नेबर ने उसको सच में मारने की कोशिश की थी। बट लेट अस सपोज ही वांट्स टू फॉल्सली इम्प्लीकेट हिज नेबर इन अ केस ऑफ अटेम्प्ट टू मर्डर। इंसिडेंट के 7 दिन बाद वो FIR लिखाने जाते हैं और लेट अस सपोज ब्राइब देके या कैसे भी ही सक्सीड्स इन रिकॉर्डिंग द FIR। और इन्होंने FIR रिकॉर्ड करने से पहले ही कई लोगों को बोला था कि नेबर ने मुझ पे हमला किया है, नेबर ने मुझ पे हमला किया है और मुझे जान से मारने की कोशिश की है। अब इस सिचुएशन में क्या ये कहा जा सकता है कि स्टेटमेंट वॉज मेड एट और अबाउट टाइम व्हेन द फैक्ट टुक प्लेस? द आंसर इज नो। क्यों? पुलिस स्टेशन 50 मीटर्स की दूरी पे था। जब इंसिडेंट हुआ आप सीधे वहां पे जा सकते थे, पर आप नहीं गए। यू सैट एट होम फॉर 7 days. So in this situation it is very possible that the witness had the opportunity to concoct the story. और ध्यान रखिएगा, हमें सिर्फ प्रोबेबिलिटी चीज कंसिडर करनी होती है, सर्टेनिटी नहीं। ऑन ब्रॉड प्रोबेबिलिटीज अगर ये लग गया कोर्ट को कि इन दिस पर्टिकुलर सर्कमस्टेंसेस द विटनेस हैड द अपॉर्चुनिटी टू कॉन्कॉक्ट और एम्बेलिश अ स्टोरी और दैट द विटनेस हैज बीन ट्यूटर्ड, ऐसी सिचुएशन आ गई, then the court will not say that it was a formal statement made at or about time when the fact took place. This is why Supreme Court said that ये जो expression है at or about time when the fact took place, it would be construed according to the fact and circumstances of the case. तो जैसे मैंने अभी आपको ये DM वाला एग्जाम्पल दिया था जिसको नक्सल उठा के ले गए, उसमें आफ्टर डिले ऑफ 10 days भी वो नहीं माना जाएगा कि वो 157 के परव्यू से बाहर है, ये नहीं माना जाएगा। ठीक है, लेकिन जो सेकंड एग्जाम्पल मैंने आपको दिया उसमें कोर्ट ये कह देगा कि yes it is outside the purview of section 157 that cannot be used for corroboration because under the fact and circumstances of this case the statement was not made at or about time when the fact took place and secondly the witness had the opportunity to concoct the story. ठीक है, बस मैंने आपको समझाने के लिए बताया है क्योंकि सुप्रीम कोर्ट तो बताता नहीं है कि भाई इसका क्या मतलब है, तो इलस्ट्रेशन मैंने ही आपके लिए बना दिया कि सर्टेन सर्कमस्टेंसेस में कुछ और चीज़ें होती हैं, कुछ सर्कमस्टेंसेस में कुछ चीज़ें हो सकती हैं। अब ह्यूमन लाइफ इतनी कॉम्प्लेक्स होती है कि देयर इज़ नो अथॉरिटी हु कैन एक्चुअली कंडक्ट अ prognosis. All right, courts and the legislature cannot conduct a prognosis in advance that what are the events that are likely to happen in future and have a certain situation cut and dried for all the circumstances or certain sections or the position of law cut and dried for all the circumstances. That is why you often see this clause that it will be construed according to fact and circumstances of the case. That is why this statement is a recurring statement in the judgments of the Supreme Court. I'll reiterate again. Statements recorded under an FIR can be used for both corroboration and contradiction, but they are not substantive evidences. I am reiterating it again and again because it is a very popular question that what is the evidentiary value of an FIR? And remember that statements recorded under section 161 of the CRPC can only be used for contradiction, they cannot be used for corroboration. ठीक है, corroboration के लिए use नहीं किए जा सकते. Now we come to section 158. It says whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it, or in order to impeach or confirm the credit of the person by whom it was made, which might have been proved that person had been called as a witness and had denied upon cross-examination the truth of the matter suggested. Now, the legislature intends by this section to submit such statements to the test of the contradiction and corroboration in the same way as if the maker of those statements was standing in the witness box. By virtue of section 158, the credibility of the maker of such statement may be impeached or confirmed in the same manner as in case of a living witness. Although, in this case, a witness cannot be actually cross-examined, but all such evidence may be given which would contradict or corroborate him. Then there are simple section of refreshing memory that you can do yourself. Till 164 there is nothing complex. It is very straightforward and simple to understand. And there are no nuances contained therein. So we can directly come to section 165. It says, judge may, in order to discover or obtain proper proof of relevant fact, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order production of any document or thing, and neither parties nor their agent shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to such question. तो basically क्या कह रहा है? Judge, in order to discover और obtain proper proof of relevant facts, कोई भी सवाल पूछ सकता है किसी भी फॉर्म में, किसी भी वक्त, किसी भी विटनेस से या पार्टी से about any fact, चाहे वो relevant हो या irrelevant हो. और he may order production of document or thing if he so sees fit. और कोई भी पार्टी ऑब्जेक्शन उस पर नहीं कर सकती, ना बिना कोर्ट की परमिशन के, that is leave of the court, cross examine any witness upon any answer given in reply to such question which are posed by the court. Now look at the proviso. Proviso says that the judgment must be based on the facts declared by this act to be relevant and duly proved. Judgment हमेशा बेस होगा relevant facts पे जो prove हो चुके हैं. And provided also that section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive, if the question were asked or document were called for by the adverse party, nor shall judge ask any question which it would be improper for any other person to ask under section 148 or 149, nor he shall dispense with primary evidence of any document except in the case hereinbefore accepted. तो ये बेसिकली सेक्शन जज इसको पावर बहुत वाइड देता है, बट एट द सेम टाइम कुछ सेफ गार्ड्स भी रखता है कि जिससे एविडेंस एक्ट इंटायरली जज का डिस्क्रेशन ना हो जाए. तो ये जो प्रोवाइजो है, प्रोवाइजो को भी ध्यान में रखिएगा. प्रोवाइजो इसीलिए बनाए गए कि जितने भी सेफ गार्ड है ना एविडेंस एक्ट में, प्राइमरी एविडेंस को लेके, और फिर प्राइमरी एविडेंस एक जनरल रूल होता है, बेस्ट एविडेंस रूल होता है, जब डिस्पेंस विद किया जाएगा इन अकॉर्डेंस विद द प्रोविजन ऑफ द एक्ट तभी आप सेकेंडरी एविडेंस एडमिट करेंगे. सेकेंडली 121 से लेके 131 तक जो प्रिविलेज कम्युनिकेशंस हैं उनको भी, उनके लिए भी सेफ गार्ड तैयार किया गया है कि जज ऐसा भी नहीं करेगा कि टोटली जस्ट इग्नोर दो सेक्शंस, या ही कैन नॉट आस्क एनी क्वेश्चन विच आर नीडलेसली इम्प्रॉपर, स्कैंडलस और वुड बी इम्प्रॉपर इन अकॉर्डेंस विद सेक्शन 148 और 149. तो ये एक तरीके से सेफ गार्ड है कि ये भी लेजिस्लेचर नहीं चाहता कि जज कंसर्न पूरी एविडेंस एक्ट को ही इग्नोर कर डाले बाय द वर्च्यू ऑफ सेक्शन 165. बट नॉनदलेस सेक्शन 165 इज़ अ वेरी पावरफुल सेक्शन. अब प्रोवाइजो का ध्यान रखिएगा कि प्रोवाइजो कहाँ कहाँ अप्लाई होता है, पर प्रोवाइजो की बातें आप छोड़ दें तो दिस सेक्शन गिव्स अ वेरी वाइड डिस्क्रेशन टू द जज. This section is intended to arm the judge with as extensive power as possible for getting at the truth of the matter. The effect of this section is that the court, in order to get to the truth of the matter before it, would be able to look and inquire into every and whatever fact it deems fit in accordance with this section. Always remember, a trial judge is not expected to act like a mere tape recorder or an umpire, or just behave and record whatever has been stated by the witness. This section, section 311 of the CRPC, are actually vested with the court in order that the court may be able to do justice between the parties. Okay? What is the purpose of the court? to do the justice between the parties. And the court cannot do justice between the parties unless he has such wide powers. So section 311 of the CRPC, section 165 of the Indian Evidence Act, similarly order 16, rule 14 of the Civil Procedure Code are some of the illustrative examples by which the legislature has vested ample powers in the court to have any witness summoned or have any document produced, whatever the court thinks fit, so that the court may be able to do proper justice. Always remember that in India, the courts are not expected to act like an empire. Alright? एक empire की तरह act नहीं करते वो. They are not the clerks of the prosecution who are just intended to blindly record whatever is being deposed by the parties. In India, the judge is expected to be proactive in a trial. He should be on a quest for truth and see that what is the real matter and issue between the parties and then do justice in accordance with that. In fact, it was often stated by Privy Council that in India, in an enormous mass of cases, it is absolutely necessary that the judge should not only hear what is put before him by others, but he should also ascertain by his own inquiries how the facts actually stand. And in order to do this, it would be frequently be necessary for him to go into the matters which are not themselves relevant to the matters in issue, but may lead to something that is, and it is in order to arm judges with express authority to do this, that is why this section has been framed. Now, Supreme Court called section 165 an extraordinary power conferred upon the court to elicit the truth and to act in interest of justice. I am quoting the judgment of Ritesh Tiwari versus State of Uttar Pradesh, AIR 2010, Supreme Court, page number 3823. Supreme Court said that a wide discretion has been conferred on the court to act as the exigencies of justice require. Thus, in order to obtain proper proof of relevant fact, the court can ask the question to the parties concerned at any time in any form, and every trial is a voyage of discovery in which truth is the quest. Therefore, power is to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in the aid of a just decision and to uphold the truth. So section 165 पे एक सिर्फ ज़्यादा से ज़्यादा short note ही आ सकता है. So whatever I have told you, you can keep that in mind. और आपको Bayer Act के ingredients primarily इस पे ध्यान में रखने. ठीक है, इसमें quest for truth, extraordinary power, ये कुछ keywords हैं. तो जब भी आप 165 पे आंसर लिखें, इन सारी चीज़ों का ध्यान रखिएगा. ठीक है, शॉर्ट नोट ही ज़्यादा से ज़्यादा आ सकता है 165 पे. ठीक है, ज़्यादा नुआंस पॉइंट नहीं है. ये बस ये है कि इट इज़ एन एक्स्ट्रॉर्डिनरी पावर वेस्टेड विद द कोर्ट. अब सेक्शन 166 तो नेगेटरी हो गया. जूरी ट्रायल तो अब इंडिया में होता नहीं है. तो बस अगर कभी भी प्रीलिम्स में क्वेश्चन आए कि ये जूरी और सेसर्स की पावर टू पुट क्वेश्चंस किधर है, तो 166 मेंशन कर दीजिएगा. Then we come to section 167. It says, improper admission or rejection of evidence shall not be a ground of itself for a new trial or reversal of the decision in any case, if it shall appear to the court before which the objection is raised that independently of the evidence objected to and admitted, there was sufficient evidence to justify the decision, or that if the rejected evidence had been received, it ought not to have varied the decision. What is the object of this section? The object is that the Court of Appeal or Revision should not disturb the decision on the ground of improper admission or rejection of evidence, if in spite of such evidence, there is sufficient material in the case to justify the decision. In other words, technical objections will not be allowed to prevail where substantial justice appears to have been done. This is a principle of all procedural laws. If the substantial justice have been done, then on mere technical objections, the decision cannot be assailed. Alright, you can see section 99 of the CPC. It says no decision shall be reversed or substantially varied, nor any case be remanded in appeal on account of an error, defect or irregularity in any proceeding in the suit not affecting merit of the case. Similarly, under CRPC, section 460 to section 465, And section 465 expressly in particular just gives you a basic principle that Court of Appeal and revisions are concerned with substantial justice, and unless and until there has been prejudice to the accused and failure of justice, till then the decision is not varied by a Court of Appeal or revision. So I hope you understand the principle behind it. Now I will tell you that under what circumstances the court will interfere with the improper admission and rejection of evidence. The legal position regarding this matter has been succinctly be summed up by the Supreme Court in the case of State of Rajasthan versus Islam. In this case, Supreme Court stated that the golden thread which runs through the administration of justice in criminal cases is that if the two views are possible, one pointing towards the guilt of the accused and other to the innocence, the view which is favorable to the accused should be adopted. The paramount consideration of the court is to ensure that the miscarriage of justice is prevented. A miscarriage of justice which may arise from acquittal of a guilty is no less from a conviction of an innocent. The principle to be followed by the appellate court considering the appeal against the order of acquittal is to interfere only when there are compelling and substantial reasons to do so. Thus, in such cases, the court usually would not interfere unless first, the finding is vitiated by some glaring infirmity in appraisal of evidence. Secondly, the finding is perverse. Thirdly, the order suffers from substantial errors of law and fact. Fourth, the order is based on misconception of law or erroneous appreciation of evidence. Fifth, High Court has adopted an erroneous approach resulting in miscarriage of justice. I'll reiterate. High Court has adopted an erroneous approach resulting in miscarriage of justice. Sixth, acquittal is based on irrelevant grounds. Seventh, High Court has completely misdirected itself in reversing the order of conviction by the trial court. Eighth, judgment is tainted with serious legal infirmities. Then the Supreme Court said, in reversing an acquittal, the court keeps in mind that the presumption of innocence is in the favor of the accused, and it is fortified by an order of acquittal. And if the view of the High Court is reasonable and founded on materials on record, the court should not interfere. However, if this court is of the opinion that the acquittal is not based on a reasonable view, then it may review the entire material and there would be no limitation on the court's jurisdiction under Article 136 to come to a just decision quashing the acquittal. So here you have it, summing up of the entire law which relates to that when will the court interfere with the order of acquittal. कब interfere करेगा appellate court और supreme court with the order of acquittal. अब देखिए है वैसे primarily CRPC का टॉपिक पर ओवरलैप करते हैं ये 167 में भी, क्योंकि ये है ना कि आपको कैसे पता चलेगा कि when will the court interfere and when will court not interfere unless you know about the parameters. ठीक है, so now you know about the parameters, so unless it falls within one of these things, till then the court will not interfere. If it falls within one of these things, then the court will interfere with an order of acquittal. वैसे ही अगर conviction का order भी perverse है, it's based on no material at all, or it is based on irrelevant material, then also court will interfere with the order of conviction. Basically, all the court has to do is be on the quest for substantial justice, not technical matters. ठीक है? That is the essence of section 167 of Indian Evidence Act. Primarily, the discussion about that on what grounds will the conviction be caused and on what grounds will the Superior Court interfere with the order of acquittal is primarily a topic of CRPC. It is not a topic of Indian Evidence Act. But you won't be able to grasp the entire essence of section 167 unless and until you have a brief idea that when can court interfere. That is why I explained the applicability about the situation that when can the court interfere in these matters. Although there are some other extra matters, but then that would become purely the discussion of CRPC. That is why I constantly say that the criminal law overlaps constantly. Okay, it jumps from one act to the other. You will see a similar thing in civil procedure matters as well, and it will jump constantly from the statute to evidence act to some other act. You will constantly see that. So basically, in your mind and in your mental makeup, you should have the ability to interlink the statutes and the section. ठीक है, ये ability आपके दिमाग में होनी चाहिए. So always keep your mind open regarding this. I always say law cannot be read in a vacuum. You cannot compartmentalize a law. ठीक है, आप ये सारी चीज़ें नहीं कर सकते. बाकी आपको सेक्शन 167 का जो स्कोप था वो मैंने बता दिया. प्राइमरली आपका एविडेंस ख़त्म हो गया. So this is the last lecture of that matter. Then I think next we'll start with civil procedure code. ठीक है, so that is it for today.